driving to the gym, figured I'd jump on, talk for a little bit. Today, let's talk about credit disputing. When you do a dispute on your credit, most instances this dispute will be sent directly to the Consumer Reporting Agency, or CRA, and this is where you tell the particular agency that they have information concerning you in their files that they're making into consumer reports that is inaccurate or incomplete, and that you want them to either modify or delete that information. So that letter structure needs to be such that it communicates the dispute properly. That's where my book, 4 Steps to Better Credit, comes in. It gives you a template on how to write that letter. But anyway, that is the start to a credit dispute, and that letter is sent to the Consumer Reporting Agency. For example, Equifax, TransUnion, or Experian. Those are 3 major consumer reporting agencies that you can send your dispute to. Now, every step along this way is where mistakes are made that really hurt consumers, and that's where I come in to try to educate you or catch you soon enough so that it can be done right for you. Okay, so either one, educate yourself on how to do it right, or do it for you. Right now, I'm giving you the education on how to do it right. To do it right, you want to address it to the Consumer Reporting Agency so that it gets to them properly. And because of all that's going on, I suggest that it be sent certified mail return receipt requested, so that you can prove that the Consumer Reporting Agency got your dispute. Because a defense by the reporting agency could be that they did not get a dispute, and you want to be sure to eliminate as many of their defenses as you can. The first defense is going to say, oh, we didn't get anything from that consumer. Well, you send your dispute certified mail return receipt requested, you're going to have a signature, date, timestamp of when they picked up the dispute, which is very important. Today, I want to talk about what happens when the reporting agency just either does not respond to your dispute or sends you a stall letter. Okay? There are a lot of things that can happen when you dispute. Today, I want to talk about what to do when the agency, the Consumer Reporting Agency, just does not respond to your dispute or sends you a stall letter. Well, as far as responding to the dispute, the Consumer Reporting Agency has exactly 30 days from the date of their receipt of your dispute to take action on it and to either modify, delete, or take any other legal action in response to your dispute. The only other legal action would be to tell the consumer specifically why they're not going to process their dispute based on a reason that's allowed under the FCRA. But they cannot just ignore a dispute, okay? They have to modify, they have to delete, or tell you a legal reason why, based on the FCRA, they're not acting your dispute, okay? All of those options are statutorily listed in what's called 15 U.S.C. 1681I. I as in invent, okay? I don't expect you to learn or know that law, but I'm just telling you the basis. When the reporting agency completely ignores the dispute and doesn't respond, that's a violation of the FCRA, specifically Section 1681I that I just mentioned to you. A huge mistake is to resend a dispute. You hear it over and over, another round. Well, that is the wrong thing to do because you've already submitted a dispute. And under the FCRA, a several things have to, are worth noting. One, the reporting agency has an obligation to respond to your dispute. So if they don't do that, you don't give them a second bite at the apple and basically send a whole new dispute. That gives them a completely new opportunity to act on a dispute that you've already sent that's expired. It being expired means their time to act on it legally has expired, and they've already violated you. And in essence, having violated you, they owe you money, and it's too late for them to reinvestigate the particular dispute. And they've ultimately pretty much admitted to what you've alleged, in my opinion, but certainly it's too late for them to act on a dispute. Their time is up. They've already violated you. And under the FCRA, they can owe you money damages for doing that. And my argument is what was disputed at that time should be basically corrected as you asked the reporting agency to do. All right. Now, if you were to sue them and prevail that they failed to do that, you would actually get money damages. The court will not force them to change that credit report under the FCRA, but imagine if that information is still there, the person would have the opportunity to sue later on that information being continued to be furnished, even though it was disputed, and the dispute did not timely verify it. So at the end of the day, just understand, if a report agency does not respond to your dispute, they have violated you at that point. The wrong thing to do is to redispute it. The wrong thing to do is to hire someone else to redispute it. The wrong thing to do is to force the person that you hired to help you, if they did, to redispute it. You don't want to do that. It starts the clock over. It gives the reporting agency a whole new bite at the apple. And you don't want to do that. All right. Next, another violation is if the report agency responds to your letter with a stall letter. A stall letter is any letter that's asking for stuff from the consumer that disputed, that either one is unnecessary and two, unwarranted. I'll give you an example. You write the consumer report agency, give them your name, address, social security number, date of birth, and go over your dispute, and they write your letter back saying, hey, we were unable to verify your identity. Please send a copy of your driver's license or passport. That's a stall letter. It is not required that you send a copy of your ID with a dispute of that type. The only kind of dispute with a report agency that requires that you submit identification is when you're asking the information be blocked because you're an alleged victim of identity theft. All other disputes does not require proof of identity be included. Now, your letter has to have information that can be used to properly identify you. So if you give them your name, address, date of birth, and social security number, that's plenty to identify you. If the report agency comes back to you and say they need an ID, that's a stall letter because they don't need an ID. They have more than enough information to understand who you are identification-wise. Next, if they send you a letter saying they want to verify your address, that's a stall letter. Your address is on the letter. You identify yourself. If your current address does not reflect in their system, you don't have to verify that change of address with them. You are giving them a new address. So again, that's another stall tactic. The mistake with that response would be to send them what they're asking for. You don't need to. I would suggest waiting the 30 days and then seeking legal advice on whether you have a claim against the reporting agency for stalling and failing to reinvestigate. What they're asking for is not needed for them to reinvestigate and give you a decision within the 30 days under the FCRA to resolve that claim. So those are tips for today.